recording. Thank you very much for joining this interview with me. Is Luca Castellani. Luca is a legal officer at Group Four at the United Nations Commission for International Commerce, and Group Four is specifically that is interesting in electronic commerce. Luca, thank you very much for joining me. We're very excited to having you in this interview. We would like to start with a brief introduction. Why don't you tell us who you are, Luca, and what is your overall work at UNCITRAL?
Thank you. Thank you very much, Axel, for inviting me. I'm very happy to discuss with you certain issues about UNCITRAL and Working Group 4. I hope to be as accurate, as insightful as possible, although, of course, these are only my personal opinions. UNCITRAL is the core legal body in the United Nations system for the harmonization and the modernization of commercial law. Now, there are here two things to be said, which are quite important to understand what we are talking about. UNCITRAL was set up in 1966. Historically, this is quite interesting. It was set up because there was the need to create a proper United Nations Commission that would take into account the interests of the three main blocks. Back when there was a Western bloc, because things were seen from Europe, so it was Western and Eastern, but it was one was capitalist, one was socialist. But there was a third one also, which was made by so-called non-aligned countries, recently independent countries or other developing countries. So historically, this is very interesting. And who knows? We have to go back to learn what happened 60 years ago in order to understand what will happen in the next 60 years. So a body in the United Nations and a body tasked with what they felt it was back then, even uniformation or unification. Now, the law is a social science. And I know this sounds a bit unusual, but I have also written it. For me, the human society are necessarily pluralistic, and therefore legal systems are necessarily pluralistic because they reflect the complexity of the human society. So even when we say unification, for me, it's a bit, it's a goal, but it's a goal that cannot be really attained in practice. Harmonization is useful, of course, because harmonization has to do with bringing together on common fundamental notions, but also adjusting to other specificities of the legal system or even of the economic system. And of commercial law, contract law and commercial law, but the main mandate of UNCITRAL is business-to-business transactions. And there is some confusion sometimes because the word trade law was used. But this is what in the US is called international business transactions. So we are talking about contracts, we are talking about dispute resolution like arbitration. And it's not the World Trade Organization, of course, it is something else. The World Trade Organization deals with regulation, or it should deal actually with deregulation. But still, it is regulation or absence thereof of trade, while we deal with facilitation, that is to say, we provide laws that mostly apply to business, mostly inspired by party autonomy. So you have there, options for the parties to adjust these laws. and of course, in a open market regime. That is the basic assumption. In the 60 years, of course, the work of UNCITRAL has evolved a lot. So because the initial focus was on unification, uniformation, then the instrument was the treaty. So the treaty allows only the deviations that are specifically listed in form of reservation, which are called declaration in our treaties, but have the nature of reservation. And then from 1985 on, 1985 there was the adoption of the model law on arbitration. Commercial, but used also for non-commercial purposes. Then from that experiment, which was very successful, we have had more and more model laws or even legislative guides in the documents that are very useful, but less binding. And in fact, in my view, you see a transformation. 60 years ago, we could look at strong national legal models and compare them and see common elements or try to find compromise positions. But now most of the work, especially the work in the space of e-commerce, digital trade, is work where you don't have national legislation. So that's why I say we move from unification to harmonization, and now we move from harmonization to modernization, because we provide some guidance to countries that don't have. In fact, it's even difficult. You may see still countries like US, or quite a bit of regulation nowadays comes from the European Union, but it's difficult for individual countries to come up with the new laws completely original. So there is the need to help that process.
Excellent. Thank you. And I do want to discuss a bit of something you said right there, and is the original intent of adopting this through a convention, through a treaty. If I do remember correctly, I think it was in the 1969 convention, actually, for UNCITRAL, where I believe it was the United States that proposed the adoption of these measures in a treaty, and that for me made sense, right? For me, most of my career has been spent in international taxation. Um, International treaties are the cornerstone of commercial relationships from the tax perspective. And I would assume that this would-be treaty would also be subject to the rules of the Vienna Convention of 1968. So for me, when I read the United States proposal to adopt this framework in a treaty, made a lot of sense, because it would have provided countries with the same rules in order to apply and somehow interpret these provisions, and avoid such disparities as you mentioned between legal systems. So it's quite interesting to me that that was something that was proposed but never adopted, and that you adopted a principle of party autonomy. So quite striking.
Yeah, there are two things to be said there. One thing is, let's say if you have a treaty on taxation, which are mostly bilateral, that's a typical regulatory instrument. So what you can or cannot do, what can be counted once, what can be counted twice, how to count it. Most of our treaties have an opposite spirit. They want to provide what I call a safety net. So that if the parties are unable or did not want to agree otherwise, then they can fall back on rules that are useful. and that help them out. A lot of it has to do with the fact that many cross-border transactions, especially when small and medium-sized enterprises are involved, don't have a proper legal framework. So, but or either the parties don't look for that, or they get guidance that is not appropriate. So, and so that's there was never the feeling that our treaties would prevail and become the world law. It was always the feeling that they would, and actually they are useful also, they impact also national law reform, but because they are a good restatement of the law. But it was always, because party autonomy prevails, it was always subject to the agreement of the parties. Then, of course, there's a lot to be said. And yes, nevertheless, normally the Vienna Convention on the Law of Treaties would apply to these treaties. And that's one reason why before I said we call them declarations, but they are reservations, because somebody didn't want to use the legal regime of the reservations in our treaties, because they are different. You see, I always say, if you take the single convention on narcotics, it criminalizes trade in narcotics. So the problem is not that the parties agree to trade in narcotics. I mean, that's a crime. and so people should, while we do the opposite. So we say, well, if you want to trade, we help you on how to do it. So it's completely different. The logic is totally different. And so
It's
if
really
I
the
speak,
opposite.
yeah, and if I speak to government officials who know the concept of treaty, but not of commercial treaty, then they
Yeah.
get confused, because they say, how can it be that the parties can change whatever they want? They say, well, because I'm facilitating them. So if they know better, let it be.
That's not our
But
job. It's not our job to tell you not what to do. It's our job to facilitate what to do.
yeah, exactly.
Okay, interesting. So, Luca, thank you. And what? So, what? Why don't you tell us about Working Group 4, about e-commerce, and what is the general goal and the topics that that grouping work for specializes in within the UNCITRAL?
Well, working group, I have to say, working group 4 has delivered significant legislation, and you can also see the evolution. Uh, it's called electronic commerce, but truly we should call it now digital trade, because electronic commerce, at least in Europe now, has more a flavor of business to consumer transactions. And we don't deal normally with transactions with consumers. So it's a bit misleading now. But in any case, so UNCITRAL started working this area already in the 1980s. And what you find very interesting, you find two things. You find some work in the area of payments, which to this day remains really the skeleton digital trade. You have it there. And back then, of course, electronic payments were high value, low volume. Now electronic payments are everything. So you have also low value, high volume, micro payments. To the point that now the transfer of value is important, but the information associated with the transfer of value is equally important. So now there is more value in the transfer of value than just the transfer of value itself. And the other work was an EDI, actually, electronic data interchange, which is a structured way of exchanging messages, which is still used. And it's interesting because we went through a lot of things, and now what people want again is to have structure in data. So we're going in a way back to where it started. And then Working Group 4 prepared in the 1990s the model law on electronic commerce, which has been adopted in more than 90 states, including Mexico. And now how can I say, it was made immortal because trade agreements now refer to that model. And they don't refer to that model law as complemented, supplemented, integrated, updated. We refer to that model law because it's a shortcut to refer to the fundamental principles. So 2001, there was the model on electronic signatures. In 2005, the Electronic Communications Convention, which was an attempt to bring the model on electronic commerce to the treaty level. And I think it has still value, and it does solve certain problems. And but it also contains some substantive provisions that update and complement the model of electronic commerce. So that treaty has been more successful as a model law than as a treaty. It has like 20 states parties as a treaty, but 30 states more have adopted its substantive provisions. Then there was a break, and then in around 2012, 2011, I was directly involved and started a bit of evolution. In the up to 2005, the idea was to transmit the information at a distance, at no cost, anywhere, instantaneously. Okay. But in 2011, there was already the idea that this was not sufficient, that what we wanted to have was data, to look into the data, to verify the quality of data, to reuse the data, to aggregate, to analyze, all of these things. So 2017, the model on electronic transfer of records, MLETR or MELITA, which had a very specific goal. The goal was to allow the use in electronic form of what the US calls transferable documents or instruments, but you would call títulos valores.
Securities.
Yeah, but of some type, not so mostly bills of lading,
Okay.
bills of exchange, promissory notes, so conocimientos de embarque, letras de cambio, pagarés,
Títulos de crédito.
cheques, títulos de crédito.
Yeah, títulos de crédito, we will call them here. Yeah, it's
Okay. Títulos de crédito. So those specific, not all títulos valores. Okay. And this was very, if you wish, very narrow. But those were the missing ones, because the problem was for centuries, they presupposed the existence of a paper document to transfer the right with delivery or endorsement. And that was an obstacle. We had to prepare functional equivalence rules. And interestingly, it was adopted in 2017. There was very limited awareness. And then, because of the pandemic, the people realized that it was important. And it was important in its own scope, because it allowed the use of these documents in electronic form. Or it was important in another way, because this was the missing element. And now you could digitalize the whole set of commercial documents. And then, there were new ideas, like nowadays, it's not surprising to say we will replace the customs declaration with the data extracted from an electronic bill of lading. So it's completely, but to do all of that, then there is the other issue, which is data quality assurance. So, and Working Group 4 actually continued the work on a text that takes a lot of inspiration for the EIDAS regulation of the European Union, but brings it to the UNCITRAL usual ways. So in a way, it is a bit more, what can I say? It's a bit more balanced in terms of institutional mechanism and ability to rely on qualified and non-qualified trust services in the same way. And the same, of course, with identity management schemes. And we adopted in 2022 the model on use and cross-border recognition of identity management and trust services. And maybe it came a little bit before of its time, but I see now a huge interest coming up. And after 2022, there were some projects now, a lot of projects are carried out by the Secretariat, some are in the working group. So last month in New York, UNCITRAL adopted a model law on automated contracting, which in my opinion is an important achievement, but it's of course in a field that is still in evolution. So one can look at it and see some useful rules. I don't know how much of that will stay in 20 years' time. But you have to go through an evolution.
Of course. Well, the model law for electronic commerce in Mexico was adopted in 2000, and we're just seeing its effects right now, just after the pandemic, as you said. So it's this model laws, these provisions required quite a maturing time in order to be, first of all, acknowledged, then understood, and then go to actual implementation in the practical sense, right? Just how people would adopt electronic commercial practices based on those laws. But I do want to touch on one point on the trust services providers, because it is quite striking to me the difference in approach between what I will call the two largest economical blocks, the European Union and the United States, because their approach towards e-commerce, it's quite striking how practical Americans are with regards to e-commerce, with the UITA, right? The Uniform Electronics Transaction Act, the e-Sign Act, and as opposed to the heavily regulated model adopted in the European Union with AIDAS. Although I will imagine that the European Union have been such diverse in terms of how many countries integrated and the differences in systems, legal systems, would otherwise require such an intricate and complex regulation, right? But it's quite striking to me how both try to solve the same problem with such radical approach, such different radical approaches. This from my perspective, right? The US seems to me they're more practical when it comes to e-commerce and trust services providers, while the European Union goes for this heavily regulated approach.
Yeah, yes, I agree in general. First of all, in the US, there is not even the notion of trust service. There is the notion of electronic signature to some extent, but then electronic signature is a tricky notion because it means at least three different things to a lot of people. There is the electronic signature as a trust service, which gives you, it depends, of course, on how you define it, but generally it gives you sufficient assurance of first of all, of the identity of a party, and then of the intention of the party with regard to a data message. Okay. Then there is electronic signature as a contract law notion, functional equivalent of a contract law form requirement to sign, which is different because a trust service, you can use it without any form requirement. Actually, you mostly use it without a form requirement. And there you end up in a labyrinth of form requirements if, say, a third party is involved, if integrity has to be assured, one thing and the other. So, and when it becomes difficult, especially, I would say, in places like Latin America, but not only Latin America. And then you have the third one, which is usually, referred to as authentication, which is more of a technical process. So verification of credentials, but even to get into a system or something. So when the lawyers maybe would focus on the first two notions, but the third one, when the technical people come in, when it comes up immediately, authentication. And so these three notions, the fact that you use the same word for three different things is not helping at all. But and then, of course, when people start thinking of digital signatures, and so they go technology specific on the use of PKI, on the use of certificates, and then it's difficult.
Very difficult. And I think you touch a very common problem, at least from the Mexican perspective, right? The adoption of electronic signatures has been quite challenging. Well, as you mentioned, the definition or the concept of electronic signature has different connotation, have different meanings, depending from where you look at from, right? From the technical perspective, from the legal perspective, from the regulatory perspective. As you said, for example, on the third one, the third type, authentication, right? Mexico, generally, the market has adopted isometric algorithms in order to produce hashes and uh, public public authentication keys. Then you have the legal notion of electronic signature as the set of data electronically produced that allows you to identify the signer and prove that he approves the content of the data message that was actually signed with electronic signature, right? And then you have another definition, another concept that you just mentioned, the certificate that allows you to create a link between the signer and the data creation used in order to create that signature. And it has been quite challenging because it seems just to me that that Mexican lawyers overall do not necessarily understand the difference between the three connotations of electronic signature and how they play out in a commercial transaction. So we have created this very rigid notion on what an electronic signature has to be, or what elements have to be considered when creating an electronic signature in order for it to be valid in a commercial transaction, right? And the reason I believe that this is happening is, well, first of all, and you touched on this at the beginning of our conversation, um, the the need or the current legal framework that regulates the use of títulos de crédito, transmissible documents. More specifically, I'm going to give you an example with promissory notes, whereby the paper was the norm. So it is quite an entrenched paradigm here in Mexico, how paper is the preferred medium to have these transmissible documents to exist, and how they are transmitted, how they are endorsed, and how they are presented in a legal dispute. So that would, to me, would be the first main challenge. How do we convince generations of lawyers, as well as businessmen and enterprises, to adopt electronic documents? That's the first challenge, and I believe that there is a natural distrust towards electronic documents, because a lot of people, I mean, it's quite common to hear a lot of questions and ifs. And because what happens if the document is false? What happens if someone used my electronic signature? What happens if I don't take care of my data creation, the data that I use to create my electronic signature? So that would be the first challenge. And the second challenge, I believe, is the technical side of e-commerce overall. Is complex, right? And you have this very interesting practice area in which legal notions collide with technical notions of technology. So from the get-go, it gets quite difficult to understand, and then translate those two. How do we take paper documents, move them to this electronic universe, right? Make them something that all people are able to use and transfer, and give them the security that those documents are, in my opinion, far more secure than paper. And then try to explain them, or try to create a system, or a framework to regulate, for example, the concept of control, right? Which is in one of the main challenges here in Mexico. How do we transfer control of electronic documents, right? Because and then again, it's this paradigm, this notion of paper documents that people do not quite seem to understand yet, and how I'm going to endorse this document, and how I'm going to present it to a judge in case of litigation, and so on and so forth.
Uh, yes, but this one could say a lot about this, of course. But I wanted to say just one thing that is very practical. The model law on electronic transfer records was endorsed twice by the G7. It has already been adopted by France and the United Kingdom. I think that at least for bills of lading, Japan will do it in 2025. Germany already has something they may complete by the end of the year. But what is more important is the private sector, in particular, the shipping lines, have made various commitments. And I am very sure, that there is already someone in Mexico who is using electronic bills of lading based on the MLETR. Of course, on a voluntary basis. But the shipping lines have made a commitment to have 100% of electronic bills of lading by 2030. I don't know if they will manage to achieve it. I hope so. Of course, they decided to say so because they had reasons to say so. But sooner or later, the number of electronic bills of lading involving import or export from Mexico will increase significantly. And, at that point, I am afraid that the law will have to catch up with the business reality. It is also true that it is a little bit different when we talk about trade financing, promissory notes, maybe checks. We can have other solutions because a lot of these documents are traded only nationally. But the bills of lading don't circulate nationally.
Mhm.
So there you need to find legal and technical standardization. Not it's not not everything can be done in the same way.
Of course. Would be surprised because in Mexico, as you mentioned, bill of ladings are do not circulate in a national context, right, between the territory. But Mexico has adopted since 2014 electronic invoicing, right? And in that context of electronic invoicing, the Mexican tax authorities pushed hard towards the adoption of what they called carta porte, which is the document that all let's say that all logistics enterprises companies that ship merchandise between Mexican territory have to issue, right, for purposes of demonstrating the merchandise they are transporting, and those are issued in an electronic format. Okay, and for two reasons. First of all, because the Mexican tax authorities want to know everything you are transporting, the right the transaction behind that merchandise, and the second reason being that in order to provide a more secure framework in order to conduct transactions between the parties, right? So you have an electronic document that is issued by Mexican taxpayers, and it goes through the Mexican tax system in order to be stamped, electronically stamped. So we have already somehow adopted that type of regulation in our framework. And as for electronic bills of lading, although they are still a rarity, a lot of Mexican companies and commerce have been somehow they have been under the obligation to practically also acknowledge electronic bills of lading with their transactions with U.S. counterparties. So it is not uncommon to see electronic bill of ladings in transactions between the U.S. and Mexico.
It's interesting. The, the invoice now there is also some confusion because first of all, there is really the electronic invoice is the interest is really rising. I think I saw reference to electronic invoice also in the stabilized text of the joint statement initiative on e-commerce. But as you said, a lot of it has to do with regulation. So it's very simple to say this is successful because we've mandated its use. So of course it becomes successful if you have to when you do it.
Correct.
And I think also they are using technical standards based on PEPPOL, which originally I think was for public procurement. But then the question is also, what's the content, how many fields do you have? How do you standardize that? Now, there is a confusion between invoices as tax documents and what they call, I think, factura aceptada in Colombia, or confirmada, or something like that. They have, I have seen very recently a very interesting case from Colombia. In Colombia, they have a registry. I take it that for you also it would mostly be based on a national registry, which in many ways it is a solution, but not always. It addresses all the issues. And with Radian is a registro de facturas electrónicas de venta como título valor. So it's kind of assignment of invoice that becomes somehow transferable.
Okay, so I'm going to give you an example.
And it is in a registry. And the interesting thing is this decision from a Colombian judge. Someone went to court saying that another company owed money, and they tried to give us evidence, what they call, I love the word, un pantallazo, A screenshot.
A screenshot, yeah.
A screenshot. So they went to court with the screenshots and say these people, and the judge made a beautiful decision saying, and this may apply also to Mexico. He said in Colombia in 1999, there was a law of electronic commerce which incorporated the UNCITRAL model on electronic commerce. But it incorporates also the rule on interpretation, uniform interpretation in light of the transnational origin. And the judge said, but we adopted in 1999, but the principle applies until today. And therefore, we cannot just interpret what we had before. We shall interpret everything up to this day. And so I will look at these screenshots in light of the functional equivalence principles of the model law on electronic transfer records, even if it was adopted 20 years after our law, and said, that's brilliant.
That's brilliant.
That's brilliant. He said the Radian could satisfy those requirements of the model law of UNCITRAL. However, because of technology neutrality, I cannot exclude the existence of other systems which would also satisfy the requirements. But in any case, this screenshot doesn't tell me anything, and so I reject the demand.
Rejected. Well, it's quite striking the similarities of what's happening in Mexico and that specific case you mentioned in Colombia.
Which, I mean, of course, it's a very valid thinking as long as people know how to do so. Because, that I find it, there is a friction in many countries, especially where there is no best evidence rule, that the requirements for the evidence in court somehow set a very high standard, which does not do justice to carrying out justice. Does not facilitate. Yeah. But I mean, for probably because here you have like a national registry or something, maybe the easiest way would be to just set in the law that a certain type of evidence coming from the registry may be presumed accurate or something like that. Yeah, but
we have a criterion similar to that, in fact. Yeah. I think it's going to get quite interesting because the recent reforms to the law that regulates the issuance of títulos de crédito of promissory notes specifically regulates or specifically provides that the validation of electronic produced promissory notes will have to be made by the judge in the electronic system in which that electronic promissory note was issued. So that will be quite interesting to see, right?
Yeah. It requires a lot of training and human capacity.
Correct. So, Luke, I think we're just right on time. I do want to thank you very much for your time. I hope we can do this on a regular basis. Perhaps another interview in some weeks to address a lot of things that I wanted to address on electronic commerce and transmissible documents, as well as electronic signature. But I do appreciate your time for this interview, and I think it's quite an amazing work that you're doing.
Thank you, for sure. If there is interest, we will have part two. It will become the soap opera of electronic signatures and electronic transfer of records. I'm sure some people are interested.
Yeah, no, well, more than you think, and we're moving towards there. I think it's important that everyone is correctly informed.
Excellent. Thank you.
Thank you. Have a great evening.
You too. Thanks. Bye-bye.